welcome back to my channel. If you are new viewer, please subscribe my channel for more videos. Today we are discussing about Chapter 12, Information to the Police and their powers to investigate. Chapter 12 related to Section 159 to Section 162. तो start करते हैं today's video. Section 159 says power to hold investigation or preliminary inquiry. Such magistrate or receiving such report may direct an investigation or, if he thinks fit, at once proceed or dispute any magistrate subordinate to him to proceed to hold a preliminary inquiry into or otherwise to dispose of the case in the manner provided in this code. Next बात करते हैं chapter section 160. Section 160 says police officers power to require attendance of witnesses. Any police officer making an investigation under this chapter may, by order in written, require the attendance before himself of any person being within the limits of his own or any adjoining station whose from the information gives or otherwise appear to be acquainted with the facts and circumstances of the case, and such person shall attend as so required, provided that no male person under the age of 15 years or above the age of 65 years or woman and a mentally and physically disabled person shall be required to attend at any place other than the place in which such male person and woman reside. Next कहते हैं subsection 2 of the section 160. The state government may, by rules made in this behalf, provided for the payment by the police officer of the reasonable expenses of every person attending under subsection 1 at any place other than his residence. Next हम बात करते हैं section 161. Section 161 says examination of witnesses by police. Subsection 1 says any police officer making an investigation under this chapter or any police officer not below such rank as the state government may, by general and special order prescribed in this behalf, acting on the requesting of such officer, may examine only any person supposed to be acquainted with the facts or circumstances of the case. Subsection 2 says such person shall be bound to answer truly all questions relating to such case put to him by such officer other than a question the answer to which would have to tendency to expose him to the criminal charge or to a penalty or forfeiture. Subsection 3 says the police officer may reduce into written any statement made to him in the course of an examination under this section, and if he does so, he shall make a separate and true record of the statement of each such person whose statement he records, provided that statement made under this subsection may also be recorded by audio, video, electronic means. Provided further that the statement of a woman against whom an offence under section 354, section 354A, section 354B, section 354C, section 354D, section 376, section 376A, section 376B, section 376C, section 376D, section 376E and section 509 of the Indian Penal Code is alleged to have been committed or attempt shall be recorded by the woman police officer and any woman officer. Next हम बात करते हैं section 162. Section 162 says, statement to police not to be signed, use the statement in evidence. No statement made by any person to the police officer in the course of the investigation under this chapter shall, if reduced to written, by signed by the person making it, or nor shall any such statement or any record thereof, whether in the police diary and otherwise, or any part of such statement or record, be so used for any purpose save and hereinafter provided at any inquiry or trial in respect of any offence under investigation at the time when such statement was made. Next, we are says, provided that when any witness is called for the prosecution in such inquiry and trial whose statement has been reduced into written as aforesaid, any part of his statement, if duly provided, may be used by the accused and with the permission of the court by the prosecution to conducted such witnesses in the manner provided by section 145 of the Indian Evidence Act 1872, and when any part of such statement is so used, any part thereof may also be used in re-examination of such witness, but for the purpose only of explaining any matter referred to in his cross-examination. Subsection 2 says, nothing in this section shall be deemed to apply to any statement falling within the provisions of Clause 1 of Section 32 of the Indian Evidence Act 1872 or to affect the provisions of Section 27 of that Act. Explanation: an omission to state a fact or circumstances in the statement referred in subsection 1 may amount to contradiction if the same appear to be significant and otherwise relevant, having regard to the context in which such omission occur and whether any omission amount to the contradiction in the particular context shall be a question of facts. So friends, this is the section 159 to 162 is complete. Next video में आपको मैं बताऊंगी इसके other section. If you like my video, please like, share and subscribe my channel. Thank you for watching.